former President Donald J. Trump at a rally in Casper, Wyoming, last month. If the Justice Department brings a case against him, the prosecution could hinge on the government's ability to establish his intent. Former President Donald J. Trump at a rally in Casper, Wyoming, last month. If the Justice Department brings a case against him, the prosecution could hinge on the government's ability to establish his intent. Credit. Natalie Baring for The New York Times. As new questions swirled this past week about former President Donald J. Trump's potential criminal exposure for seeking to overturn the 2020 election, Mr. Trump issued a rambling 12-page statement. It contained his usual mix of outlandish claims, hyperbole and outright falsehoods, but also something that Trump allies and legal experts said was notable and different: the beginnings of a legal defense. On nearly every page, Mr. Trump gave explanations for why he was convinced that the 2020 election had been stolen from him and why he was well within his rights to challenge the results by any means available. What happened at the Capitol on January 6, 2021, Mr. Trump wrote, stemmed from an effort by Americans to hold their elected officials accountable for the obvious signs of criminal activity throughout the election. His statement, while unfounded, carried a particular significance given the intensifying focus on whether he could face criminal charges. If the Justice Department were to bring a case against him, prosecutors would face the challenge of showing that he knew, or should have known, that his position was based on assertions about widespread election fraud that were false, or that his attempt to block the congressional certification of the outcome was illegal. As a potential defense, the tactic suggested by Mr. Trump's statement is far from a guarantee against prosecution, and it presents obvious problems of credibility. Mr. Trump has a long history of saying whatever suits his purposes without regard for the truth. And some of the actions he took after the 2020 election, like pressing officials in Georgia to flip enough votes to swing the outcome in that state to his column, speak to a determined effort to hold onto power rather than to address some broader perceived vulnerability in the election system. But his continued stream of falsehoods highlights some of the complexities of pursuing any criminal case against him, despite how well established the key facts are at this point. And the statement also reflected steps Mr. Trump is taking behind the scenes to build a new legal team to deal with an array of investigations, including into his pressure campaign to change the outcome of the election in Georgia and his taking classified documents with him when he left office. Evan Corcoran, a white-collar defense lawyer and former federal prosecutor brought on by Mr. Trump, was involved in drafting the document, according to two people briefed on the matter. Mr. Corcoran has also represented Stephen K. Bannon, a Trump ally who has been indicted by the Justice Department for refusing to cooperate with the House committee investigating the Jan. 6 attack. Mr. Corcoran and a spokesman for Mr. Trump did not respond to a request for comment. The statement came during a week in which the House committee's hearings drove home Mr. Trump's potential criminal and civil legal exposure by highlighting testimony from aides and advisors documenting what he had been told, and when, about the validity of his election fraud claims and the legality of his strategy for hanging on to power. The themes of the January 6 House committee hearings. Making a case against Trump, the committee appears to be laying out a roadmap for prosecutors to indict former President Donald J. Trump. But the path to any trial is uncertain. Day 1, during the first hearing, the panel presented a gripping story with a sprawling cast of characters, but only three main players: Mr. Trump, the Proud Boys and a Capitol Police officer. Day 2, in its second hearing, the committee showed how Mr. Trump ignored aides and advisors in declaring victory prematurely and relentlessly pressing claims of fraud he was told were wrong. Day 3, Mr. Trump pressured Vice President Mike Pence to go along with a plan to overturn his loss even after he was told it was illegal, according to testimony laid out by the panel during the third hearing. At its third hearing on Thursday, the committee built a case that Mr. Trump had plunged ahead with a scheme to have Vice President Mike Pence unilaterally overturn the 2020 election even though Mr. Trump had been told it had no legal basis. The Justice Department is investigating a number of elements of the Capitol riot and the broader effort by Mr. Trump and his allies to keep the White House despite Joseph R. Biden Jr.'s victory. Attorney General Merrick B. Garland has given no public indication that the department is building a case against Mr. Trump, who has long contended that the investigations into the January 6 attack are partisan and unfounded and whose side of the story has not been presented in the House committee's hearings. But the panel's investigation has already generated evidence that could increase the pressure on Mr. Garland to move more aggressively, a course of action that would carry extraordinary legal and political implications. After prodding from the Justice Department, the House committee signaled in recent days that it would start sharing some transcripts of its witness interviews with federal prosecutors as early as next month. Image. Greg Jacob, left, who had been chief counsel for Vice President Mike Pence, and J. Michael Luttig, a conservative former judge, at a hearing on Thursday held by the House committee investigating the Jan. 6 attack. Greg Jacob, left, who had been chief counsel for Vice President Mike Pence, and J. Michael Luttig, a conservative former judge, at a hearing on Thursday held by the House committee investigating the Jan. 6 attack. Credit. Hae-Yoon Jang / The New York Times. In a civil case related to the committee's work, a federal judge concluded in March that Mr. Trump and the lawyers who had advised him, John Eastman, had most likely committed felonies in their effort to overturn the election. The illegality of the plan was obvious, Judge David O. Carter of Federal District Court for the Central District of California concluded in that case. Judge Carter cited 2 crimes that he said the 2 men were likely guilty of committing: conspiracy to defraud the United States and obstructing a congressional proceeding. Members of the House committee have made similar suggestions, and some lawyers have contended that Mr. Trump could also be vulnerable to a charge of seditious conspiracy. But successfully prosecuting the potential charges suggested by Judge Carter and others could depend on establishing Mr. Trump's intent, an issue that his statement this past week appeared to address with the argument that he believed his challenges to the outcome were grounded in legitimate questions about the conduct of the election. Daniel L. Zelenko, a white-collar defense lawyer and former federal prosecutor, said that in all of the potential crimes that were being looked at in connection with Mr. Trump's conduct, the Justice Department would need to show that he had the intent to commit a crime. Mr. Zelenko said that while the new details revealed by the committee would help prosecutors in proving intent, the government still had a range of other issues to overcome in building any prosecution. The key is having contemporaneous evidence that he was saying that he knew the election was not stolen but tried to stay in power anyway, said Mr. Zelenko, a co-chair of the white-collar defense practice at Crowell and Moring. The problem with Trump is that you have to try and get inside his mind, and he has such a history of lying and pushing falsehoods that it makes it difficult to determine what he really believes. Aside from the evidence the committee has already revealed, the panel has received other testimony that undermines Mr. Trump's claim that he thought he really won the election. According to 2 people briefed on the matter, Alyssa Farr Griffin, the White House communications director in the days after the election, recently testified to the committee that Mr. Trump said to her in November 2020 words along the lines of, "Can you believe I lost to Mr. Biden?" Image. At its hearing on Thursday, the House committee built a case that Mr. Trump had plunged ahead with a scheme to have Mr. Pence unilaterally overturn the election even though Mr. Trump had been told it had no legal basis. At its hearing on Thursday, the House committee built a case that Mr. Trump had plunged ahead with a scheme to have Mr. Pence unilaterally overturn the election even though Mr. Trump had been told it had no legal basis. Credit. Doug Mills / The New York Times. In a television interview last fall, Ms. Griffin, who did not respond to a request for comment, acknowledged one of the complicating factors in determining what Mr. Trump may have believed. She said Mr. Trump might have changed his mind in the aftermath of the election. "He told me shortly after that he knew he lost, but then, folks got around him," Ms. Griffin said on CNN, referring to outside advisors who pushed false election fraud.